forms of contract. Ano ba yung mga forms ng contract? Di ba nasabi natin kanina that contracts are consensual. Ibig sabihin, the mere giving of consent is enough to is enough to form a contract. Gaya ng sabi dito sa general rule, contracts shall be obligatory in whatever form they may have they may have been entered into provided all essential requisites are present. Basta present si COC, merong consent, merong object, merong consideration, and they agreed. Yan nga, dahil nga may consent, the contracts must be obligatory kahit ano pa ang form niyan. Okay? Of course, there are exceptions. May mga exceptions tayo. The exceptions are when the law requires that it be proven in a certain way or that it be made in some form for validity or enforceability. So may mga types ng contracts na hindi siya magiging valid or hindi siya magiging enforceable kapag wala siyang specific form. Okay? First, there are contracts which are supposed to be in writing or nakasulat kahit nakasulat siya for it to be valid. Okay? So first, donation of real property. Donation of real property must be in writing. Kailangan nakasulat siya, the donation and the acceptance and acceptance kasi naalala niyo, 'di ba? Nung last time na na-discuss natin yung donation, yung in the context of donation, kailangan may acceptance. So kapag nag-donate ng real property, the acceptance must be in writing. In fact, it must be in a public instrument. By public instrument, we mean that it is notarized. That it is notarized para it's as if it's a notice sa lahat ng tao that donation happened and the acceptance also happened. So, yun. Donation of real property, kailangan nakasulat siya, and in fact, it must be in public instrument. Okay? Donation of personal property exceeding 5,000. Kapag mag-donate ka ng isang bagay ng more than 5,000, it must be in writing. Kailangan nakasulat siya. Pero not necessarily in public instrument. Okay? So, pwede na nakaano lang, na handwritten or encoded, pirmahan, mga ganyan. Ito, sale of land through agent. Ito naman, kung gagamit ka ng agent sa pagbebenta ng lupa, it must also be in writing. The same with pagbebenta mismo ng lupa. But in that case, na siya, public instrument ang kailangan. Okay? Stipulation to charge interest. Okay. Ito hindi pwedeng mag-set ng interest ng hindi nakasulat. So, kailangan nakasulat siya para maging valid yung pag-charge ng interest. Otherwise, kung hindi valid dahil hindi nakasulat, pwedeng it may be reduced to the legal rate. Depende sa court. And chattel mortgages. So, itong chattel mortgages, kunwari, sinangla mo yung yung sasakyan or cellphone, mga ganyan, kailangan may kasama siyang affidavit of good faith. So, this must be in writing as well. Itong chattel mortgage. So, yun. That's one. So, itong mga klaseng contracts, although this is not the complete list, you can just look it out sa provisions ng law. So, itong mga klase ng contract na to need to be in writing para maging valid sila. Okay, another exception is in a public instrument to be effective against third persons. There are certain contracts that need to be in writing para maging effective siya as opposed to other persons. Like contracts involving real rights, like pagbebenta ng lupa, pag-relinquish ng lupa, pag-donate ng lupa, mga ganun. Or pag-donate ng buildings, pagbenta ng buildings, mga ganyan. Since these are real rights, they involve real rights, they must be in public document. Kailangan naka-notarized document sila. Okay. Or renunciation of hereditary or CPG rights. Ano itong hereditary rights? Yung mana mo sa lupa, kapag mag-waive ka ng pag quit claim, ito yung tinatawag na quit claim. Kapag nag-quit claim ka ng ano mo, ng claim mo sa isang sa mana, it needs to be in public document para maging effective as against third persons. And CPG rights, yung karapatan mo sa conjugal partnership of gains. If you married under the yung conjugal partnership of gains, you need to renounce kung ayaw mong kunin yung properties mo doon at i-renounce mo siya, you can do so in a public instrument para maging valid, para maging effective siya sa third persons. And all other contracts exceeding 500 pesos in amount, para yung ano nyo, yung contracts nyo na with the value exceeding 500 in amount, kailangan nakanotaryo siya para maging effective against third persons. Pero it's effective kahit naman private instrument. Kaya lang, the effectivity is only limited sa inyong dalawang parties, not really as against other persons. And finally, there are types of contracts which are supposed to be in writing to be enforceable. Example of this are yung contracts covered by the statute of frauds. Now, itong statute of frauds are sets of this is a provision of law na nagsasabi na something needs to be in writing, para to protect the rights of the debtor and the creditor. Naka-enumerate ito sa batas, but unfortunately, we don't have enough time to enumerate this. But siguro kung mayroon tayong time later sa integration, we will discuss this. So yun yung mga matters relating to sa forms ng contracts. Again, as a general rule, hindi kailangan a contract is valid basta meron yung COC. Exceptions ito mga ito. Kumbaga, may mga special requirements sila kasi usually these are very important, these are more important relationships or more important contracts that na kailangan mo ng evidence. So, kaya mo siya pinapanotarize or kaya mo siya sinusulat in writing. No? So, another topic related to contracts is reformation of instruments. Now, what if yung napag-usapan nyo orally ay sinulat nyo sa contract pero iba yung nakalagay sa contract at iba yung oral. Usually kasi there could be a lot of causes kung bakit pwedeng magkaroon ng discrepancy doon sa written form at sa oral sa napag-usapan nyo originally. Pwedeng pangit yung grammar nung gumawa at nabago yung meaning ng words, nabago yung agreement in general dahil doon sa mali-maling grammar nung nagsulat, or siguro may nagkamali lang sa may nagkamali lang doon sa may nagkamali sa pagkaka-phrase ng instrument itself. So the remedy is to reform the instrument, to baguhin siya. Baguhin siya to reflect kung ano talaga yung napag-usapan, kung ano talaga yung original intention ng parties. Reformation of instrument is the remedy where there has been a meeting of the minds. Merong napag-usapan, merong meeting of the minds about the object and cause. Therefore, this is a contract. Merong napag-agrihan about sa object, kung ano yung magiging paksa nung contract, at kung ano yung consideration, magkano yung bayad, or ano yung bakit nila ginawa yung contract na yan. But there is a failure to express the true intention of the parties dahil kumbaga nagkaroon ng failure na i-express kung ano man yung totoong intention ng mga parties doon sa written form ng contract, which may be due to mistake, nagkamali lang, kumbaga inadvertently, na napalitan yung meaning because of clerical error or English error, pwede rin, or fraud or inequitable conduct, pwede rin naman na sinadya na i-phrase in a different way, pero iba pala yung napag-usapan doon sa totoong dun sa nakalagay dun sa kontrata, or by mere accident. Ano lang, accidentally siguro may na-omit or whatever. May ano dyan, may pwedeng magkaroon ng reformation of instrument. Yung mistake kanina is yung kunwari, or yung accident, yun yung clerical, sorry, I'm mistaken there. Yung sa mistake, merong hindi na pagkaintindihan on a circumstantial yet a circumstantial and important part of no contract, which may be hindi talaga yun yung yung intention, but what's written, so nagkamali. So the instrument can be reformed because of that. Okay. So yun yung remedy mo kapag mali yung nakalagay dun sa contract at sa true intention. Okay, so let's go to interpretation of contracts. So what if there are doubts doon sa phrasing ng contract, or there are doubts doon sa mismong meaning or interpretation ng contract? Now, of course, if the intention is clear from the contract's language, we don't have to do anything. We just have to interpret it literally kung ano yung nakalagay doon. Now, if the intention is not clear, the intention of the parties shall prevail, which can be na maaaring ma-ascertain by interpreting the contract as a whole and according to the usage and custom of the place. So, kung hindi malinaw yung intention, pwede mong you need to circulate back doon sa intention talaga ng mga parties na pwede nating makita, one, by interpreting the contract as a whole. Titignan mo yung kontrata sa kabuuan, ano ba yung intention nila, mga ganyan. And according to the usage or custom of the place. Titignan mo rin yung custom or yung usage doon sa lugar, kung ano ba yung ibig sabihin ng mga nakalagay doon, etc. You need to interpret it that way. Now, if these rules are not enough, you can always interpret the contracts in this wise. Kapag gratuitous siya, kumbaga kapag if there is, gaya nga nasabi na discuss natin kanina, yung gratuitous ay out of liberality, kumbaga dahil mabait ka, or dahil and because of your generosity you give to someone. Now, pero kung yung instrument mo ng donation or instrument mo for giving someone a favor ay kumbaga ay defective, or malabo, it is doubtful, it's as if hindi mo ginawa yun. Kumbaga parang magiging void yung donation if the doubt is substantial. Kumbaga kung sobrang importante nung part na mali, or sobrang substantial, sobrang laki ng diferensya nung doubt, sobrang laki ng epekto nung doubt doon sa mismong instrument, pwedeng ma-invalidate yung it can be considered inexistent kung substantial yung doubt. If the contract of donation, for example naman, ay merong incidental lang naman yung doubts niya, and then yung interpretation that will yield the least transmission of rights ang pipiliin, ang gagamiting interpretation. Ano ito ibig sabihin natin when we say least transmission of rights? Kumbaga yung kung ano yung interpretation, 'di ba maraming interpretations yan, kasi nga doubtful, there is doubts doon sa incidental aspects ng contract. Now, yung pinaka yung sa gratuitous is yung if the doubt is incidental only, yung kung ano yung interpretation na mas konti yung mawawala dun sa donor, yun yung gagawin natin. Yun yung pag-interpret dun sa instrument. Okay? If it's onerous naman, gaya nung nasabi natin kanina, yung may you give something in exchange for another, kumbaga may kapalit, hindi naman siya out of liberality or hindi naman siya donation, yung kung may malabo doon sa contract, it can be interpreted in such a way na magkakaroon ng greater reciprocity of rights. Ibig sabihin, kung ano ba ang mas fair? Kasi 'di ba nga onerous 'yon. You give something, you receive something, ano? So, ano ba yung pinaka-fair na arrangement between the two? Yun yung mananaig. Kumbaga, paano ba magkakaroon ng reciprocity between the parties? Greater reciprocity among the parties. Yun yung interpretation na gagamitin natin dun sa doubtful na contract. But again, you only use these rules kapag hindi malinaw yung intention ng parties. Pero kung malinaw naman yung intention ng parties, then you apply the literal. And finally, on the topic of contracts, meron tayong mga tinatawag na defective contracts where this is arranged in a manner na from the lighter defects to the more grave defects ng contracts are discussed in this topic. So there are 4 kinds of defects of contract. We have what we call rescissible contracts, we have voidable contracts, we have unenforceable contracts, and void or inexistent contracts. So here, we have rescissible contracts. Okay. Ano ba itong mga rescissible contracts? Generally, these rescissible contracts are valid contracts, ano? However, they can be rescinded by competent court. Naalala niyo naman siguro yung last time, no? Yung discussion natin on rescission. So, yes, they are valid, but if they can be invalidated, they can be rescinded by the court. Okay. On what basis? Ano? Usually, itong rescissible contracts are usually involves damage or lesion na tinatawag, ano? So itong sa rescissible contracts, ito yung mga defects na pwedeng mag-fall under rescissible contracts. Kung ba ito yung mga pwedeng maging rason kung para i-rescind yung contract. Una, damage or lesion to guardians and absentees. So, for example, you are the legal guardian ng isang tao, ng isang unemancipated minor, for example, minor de edad siya, no? Pero meron siyang properties, pero since you are the guardian, ang ginawa mo is binenta mo yung property, the same with executors and administrators, I believe. So binenta mo yung property and absentees rather. So binenta mo yung property na kumbaga at a very low price, to the point na almost one fourth nung value ng property ay nawala doon sa sale or doon sa disposition na ginawa mo. So kumbaga because of yung pagbenta mo at a lower price, nagkaroon ng economic disadvantage yung iyong guardian, yung ward rather, or yung nagkaroon ng damage yung absentee. For example, pinabenta sa iyo kasi nasa ibang bansa siya, pero because of yung pagbenta mo ng mura, ganyan, nawalan ng one fourth ng supposedly na matatanggap niya from the proceeds of the sale. So that is lesion or damage, ano? Also, another rescissible contract is contract in fraud of creditors. For example, ganito. May mga naghahabol sa iyo na mga nakautangan mo. What do you do in order to avoid yung paniningil nila? What you do is dispose yung mga properties mo or magbayad ng mga utang mo na hindi pa naman due, undemandable. Kumbaga, i-transfer mo sa iba, ibenta mo sa iba yung property, ibigay mo sa mga kamag-anak mo or sa mga trusted people mo yung property para kapag habulin ka na ng mga creditors mo, wala silang makikita basically. So that is a contract in fraud of creditors. So for example, binenta mo yung lupa mo para pag ano, or binigay mo siya rather sa dinonate mo siya sa isang friend na or ano, pinamigay mo yung bagay para in case na ano uh, na maghabol yung creditors mo, wala ka talaga mapapakita. That's a contract in fraud of creditors, and that can be rescinded by the courts. Or contracts involving things under litigation without the consent of yung plaintiff, ano. So for example, you are the defendant in a case, tapos ang yung property is under litigation. Kumbaga nililitis pa lang sa kaso, pero ang ginawa mo, yung property na yon ay binenta mo para later on walang if ever manalo yung naghabla sa wala siyang makukuha. Well, that is a rescissible contract. Ano? So if under lease pendants yung property, kumbaga dahil kunwari subject of a court action yung property, hindi pa na-settle kung sino may-ari, pero dahil binenta mo na yung lupa para eventually wala na, parang in fraud of yung plaintiffs, nang walang consent ng plaintiffs yung pagbenta mo, that is a rescissible contract. So again, these contracts are not really that have minor defects, but these defects can lead to the rescission of the contract by a competent court. Again, emphasis on the rescission by a competent court kasi only a competent court can rescind or can invalidate a rescissible contract. Okay? Hindi pwedeng, rescissible yan. I-rescind na natin. Hindi pwede yan. Okay? So, that is rescissible contracts. Another type of defective contract is avoidable contract. So, avoidable contract is valid until annulled. Valid until annulled. So, if there's no action to if there's no action to annul the contract, well, it remains valid. Kasi in truth, valid naman siya, no? Kaya lang, it can be annulled. There is a reason to annul the contract, or there is a reason to invalidate the contract also. So here, what can be the source? Ano yung mga pwedeng maging rason para maging voidable ang isang contract? First is legal incapacity to give consent of one of the contracting parties. Remember, gaya nung nasabi ko kanina, for consent to be valid, kailangan yung parties can legally has the legal capacity to enter into a contract, Pero if one of the parties is not capable of giving consent, or is not does not have the legal capacity, kunwari minor yung isa sa mga parties, it can be voidable in the sense na valid siya, yes, pero it can be annulled. There is if you have cause to annul it, kumbaga if you file an action in court annulling yung contract, then it can be annulled. May reason para i-annul siya. Also, if there is a vice of consent of one of the contracting parties. Remember, yung kanina, di ba nakita natin yung mga vices of consent, yung duress, undue influence, mga ganyan. So, if there's vice of consent, kahit yung isa sa mga enumerations na nabanggit natin before, if there's vice of consent of one of the contracting parties, the contract is voidable. Dahil voidable itong contract na ito, ibig sabihin, pwede mo siyang i-annul. Pero the caveat here is it is not voidable forever. It is not voidable forever. Kung for example, alam mo na legally incapacitated pala yung isang party sa contract nyo, or nagkaroon ng vice, for example, ikaw yung in-intimidate, pero nung wala ng threat or wala ng undue influence, hindi mo pa rin inannul yung contract, after a while it becomes cured. Kumbaga nako-cure siya. What do you mean when you say it's cured? ano na siya, magiging valid na siya. Hindi mo na pwedeng hindi mo na pwedeng i-contest yung validity niya kasi you have the sufficient number of you have the sufficient time para i-question yung validity niya, pero dahil nga hindi mo ginawa, yung yung right mo to annul the contract may be waived. So yun, pwedeng after a while mako-cure na yung defect. So dahil cured na yung defect, wala nang defect and it becomes a valid contract. Again, dahil voidable nga siya, valid nga siya until it is annulled. So you have to annul it first kung gusto mong mawala yung contract, kung gusto mong ma-invalidate yung contract. Okay? Next is unenforceable. Ano naman tong unenforceable? Basically, itong unenforceable, it means na it cannot be enforced by a proper action in court. So kung yung resiscible at voidable kanina, may remedyo pa, it can be enforced by yung kunwari, kung if there is vice of consent, or kung if it's a contract in fraud of creditors, you can rescind or you can annul yung contract dun sa unang dalawa sa taas. Pero dito sa unenforceable, wala kayong recourse. Kumbaga, hindi niyo siya pwedeng hindi niyo siya pwedeng enforce sa court because there is really substantial defect in the contract. Merong malalang defect sa contract na hindi mo siya mai-enforce sa korte. Kahit na anong gawin mong pagkaso, it will just be kumbaga, there's no the court cannot resolve it. Okay? What are examples? Contracts entered into the name of another if in the name of owner without authority or in excess of authority. Kumbaga, kapag if you are, for example, an agent ng isang tao, kumbaga ang authority lang sa iyo ay ang authority lang sa iyo ay ibenta yung lupa at ibigay yung proceeds doon sa tao, yung sa principal mo. Kumbaga, ikaw si ahente ng lupa, ang authority mo lang ibenta yung lupa tapos ibigay yung pera doon sa may-ari. Pero ang ginawa mo is, as agent, binenta mo yung lupa, nakuha mo yung pera, ang ginawa mo, bumili ka ng sasakyan. That contract is unenforceable. Because that is, yung subsequent na pagbili mo ng sasakyan ay wala yun sa authority mo. Or, contracts entered into sa pangalan ng principal, pero yung kunwari, ang sinabi lang ng principal sa kanya, ang ibenta mo lang ay 1 hectare ng lupa, pero ang binenta mo ay 2 hectares na lupa ng principal. So yung contract covering yung sale ng 1 hectare ay unenforceable. Kumbaga, because it is in excess of authority na binigay sa iyo ng owner. So that is an unenforceable contract. So again, also, if there's non-compliance to the statute of frauds or there is no writing in if a contract is not in writing in violation of yung tinatawag natin na statute of frauds, kasi may mga listahan ng mga contracts that need to be written, gaya nga ng na-discuss natin kanina under the statute of frauds. Kapag di mo yun na-comply, yung contract is unenforceable by law. And also, if both parties are incapacitated to act, if yung parehong parties ay walang capacity to act, for example, pareho silang minors, nag-contract yung dalawang minors, that is unenforceable. So it cannot be, kumbaga, yung contract na yun, kahit anong gawin mo, hindi mo siya pwedeng enforce sa court. Okay? Yun. So, if if for example, merong without kung merong excess of authority, for example, hindi naman yun yung sinabing gawin mo pero ginawa mo siya, yung contract na yun, na resulting contract nung pagsuway mo dun sa utos ng principal mo, is in excess of authority, so yung contract na yun cannot be enforced in court. Hindi ka pwedeng maka-obtain dyan ng hindi ka pwedeng maka-obtain dyan ng anything because that is unenforceable. Ano? So yun, or if in a contract dalawang minors ang nag-enter into the contract, none of the parties can claim anything from that contract because it cannot be enforced in court, no? So yun. And finally, the most defective of all of them is itong void or inexistent. Itong void or inexistent contract, it does not create rights and cannot impose obligations. Hindi ka pwedeng mag-create ng karapatan dito sa defective rights at hindi ka rin pwedeng mag-impose ng obligations. Why? Okay? Because in the first place, it's not a contract, or if yun, so hindi siya contract, so there's a defect in one or all, one or some or all of the the requisites of contracts. 'Di ba? Remember natin yung COC, ano? Merong defect either sa consent, sa object, or sa consideration. Una, if it's contrary to law, morals, and good customs, public order, and public policies. LMGPP na naman tayo. Ano? So, if it's contrary to LMGPP, it is void. No? Kasi nga, ano yung defect dito? Anong requisite ng contract ang defective dito? Here, ang defective ay yung object. Ano? The object of the contract itself is against the law, or against morals, against good customs, against public order, against public policy. So dahil wala tayong object, hindi siya contract. So it's void or inexistent. It does not exist in the first place as a contract. Or contract is expressly prohibited by law. Gaya nga nung nasabi natin kanina, yung donation ng spouses to each other, that is expressly prohibited by law. Therefore, it's void. It has no effect. It does not create rights. It does not impose obligations. Ano? And of course, inexistent contract, hindi tawag natin na if one or some of the requisites of a valid contract is inexistent. For example, wala namang cause, or wala namang object, ano? Or worse, walang consent, no? So that's not a contract at all. That is inexistent. So ito yung mga klase ng defective contracts under the law. So unfortunately, you need to familiarize yourself dito sa mga contracts na to, kasi later on tatanungin kayo kung ano yung anong klaseng contract anong klaseng defect ang meron yung contract na to, at anong klaseng defective contract siya. Is it rescissible, voidable, unenforceable, or void or inexistent? This is a major part of yung this is a major part of your exam, so be wary of this. So again, under rescissible contracts, nagkaroon ng damage yung guardian or absentee, or yung estate in the case of executors or administrators. There's contract in fraud of creditors, mga ganyan. If it's a contract involving things which are subject of litigation, or nasa pa lang, nililitis sa korte, no? So those are yung those are the things that we need to consider. So those are rescissible contracts. Voidable contracts naman, which are valid until annulled, yung kapag yung walang legal capacity yung isa sa mga contracting parties, or there is vice of consent. Again, yung vice of consent is yung duress, undue influence, mga ganyan, yung mga nabanggit natin kanina na vices of consent. So unenforceable naman, or it cannot be enforced by a proper action in court, is yung contracts entered into in excess of authority, in the name of the owner without authority or in excess of authority, non-compliance, solicitation to frauds, or both parties are incapacitated to act. And it is void or inexistent, and it does not create rights or impose obligations if it's contrary to law, morals, good customs, public order, and public policy. If it's a contract expressly prohibited by law, and if it is inexistent, is if one of the requisites of a valid contract does not exist. So contracts are actually the concept of contracts is really long. medyo mahaba rin yung coverage ng contracts because of yung limited time natin. We limited our discussion to these important matters in contracts. So, if you have questions later, we will entertain them in class as usual. And again, you need to exercise caution in reading yung mga provisions ng obligations and contracts because they can be nakakalito sometimes, no? So, thank you guys and good evening. Uh, thank you for listening.